Welcome back to another video with Hugh James, and I'm up in the London offices today, and I'm joined by Nia, who you may have seen in previous videos, and Gurminder, who's just joined the team, and we're going to be talking about non-freezing cold injuries. So welcome both, thanks very much for joining us. So tell us a little bit about the team's work with cold injuries here at Hugh James.
Firstly, thank you for coming back and interviewing with me. Both of us are part of the non-freezing cold injury team at Hugh James, alongside 10 others. We're part of a wider military specialist team offering a wide range of legal services. Non-freezing cold injury and cold injury claims typically include, like I said, non-freezing cold injury, freezing cold injury, frostbite, frost nip, and on some occasions they are also referred to as trench foot. More commonly these days, cold injuries and non-freezing cold injuries or freezing cold injuries are known as NFCIs and FCIs. They typically affect the feet and the hands, but some of our clients do complain of symptoms to their ears too.
So injuries to the extremities, basically then. So expand on that a little bit for us if you could, Gurminder. So what is a non-freezing cold injury?
Right, a non-freezing cold injury is an injury that's sustained as a result of excessive exposure to cold temperatures. Military personnel are more susceptible to developing non-freezing cold injuries because of the exercises that they take part in and also the promotional courses that they undertake. And also due to the wet and cold conditions in the UK as well, they're more susceptible to developing non-freezing cold injuries. Non-freezing cold injury symptoms can consist of numbness, pain, tingling, swelling, discoloration, and in some cases you can get excessive sweating as well. So these are the symptoms that you would need to look out for.
Okay, and who would be at risk then of developing a non-freezing cold injury?
Gurminder touched upon that. So it is recognised that military personnel are more susceptible to sustaining cold injuries purely down to the nature of their service. Military personnel are often in cold and wet conditions, and they explain to us that they've sustained these injuries whilst on exercise, on promotional courses, or are on deployments, and are simply down to the nature of those exercises or deployments and the conditions that they're exposed to.
Okay. And does the risk vary between individuals in terms of non-freezing cold injuries?
It does, and like Nia said, if you're in the military, you're more likely to get a non-freezing cold injury. But studies have been carried out that if you have service personnel that are of African, Caribbean and Black British descent, they are 30% more likely and more susceptible to get a non-freezing cold injury.
Wow. Well, that's a big difference.
And for that reason as well, within our cohort of claimants, we represent a number of Commonwealth individuals who have moved over to the UK to serve for the British Armed Forces, and then because they are more susceptible, they then have unfortunately sustained those injuries.
Okay, that's really interesting. And what about negligence then? So how can negligence play a part within a non-freezing cold injury?
Well, the Ministry of Defence, just like any other employer, owes a duty of care to its employees. So all service personnel are owed a duty of care. There's policies and guidelines that the Ministry of Defence have to follow when it comes to climate injuries, including non-freezing cold injuries. If you're bringing a claim for a non-freezing cold injury, the burden of proof is on you as the claimant to prove that the Ministry of Defence has breached that duty of care. Examples of negligence in non-freezing cold injuries can range from a failure to provide adequate kit, a lack of training so that a non-freezing cold injury wasn't picked up at the time. If it is picked up, perhaps there'd been a failure to then refer that individual onto a medical officer. That can also amount to negligence as well. Obviously, each case will have its own separate facts, and those would need to be explored in detail. So that was just few examples of what can amount to negligence in non-freezing cold injury claims.
On that training point as well, it could include the failure to provide the individual with training, so that individual doesn't know how to identify, treat and deal or report with an injury if they are starting to suffer with those symptoms.
Yeah, it's a case of you don't know what you don't know, and if you're on exercise and you don't know what a non-freezing cold injury looks like, feels like, presents as, then you don't know what's going on really.
And going back to the Commonwealth point, some of our claimants would have been faced with those conditions for the very first time, and they will not recognise that they're suffering from a cold injury because at the time they actually think that it's a normal reaction to the cold, and unfortunately they stay on the exercise or stay on the course, and that injury gets worse, and that's down to a failure to train them on identifying what those symptoms are and how to prevent or treat them.
Yeah, great point. And in terms of bringing a claim then, who can bring a claim?
So claims can be brought by those that have served for the British Armed Forces, whether you're still in service, whether you're out of service, or whether you're part of the reservist force. You're not prevented from bringing a claim if you're still in service, which in our experience a lot of service personnel believe that they have to wait until the day they've left service before they seek legal advice. I would urge anyone that thinks that they've got an injury or potential claim for this injury to speak to a specialist solicitor as soon as they become aware, because delay may prevent them from bringing the claim in future.
I think that's a great point, and you're right. Coming from a military background, the perception is that you cannot make a claim while you're still serving. So I think that's really great information and vital information. So what about compensation then? So how is compensation assessed in these claims?
So there are two heads of loss that you claim in a civil claim. So you would look to recover general damages, which is for the actual injury itself, for the diagnosis of a non-freezing cold injury. And we would instruct a medical expert to make that diagnosis and assess the severity of that and the impact that it would have on your day-to-day life as well. The second head of loss is something called special damages, and that would include loss of earnings. So it would include future loss of earnings and also any current loss of earnings. So if you've been medically downgraded and discharged as a result of your non-freezing cold injury, you've lost out on a military career. So you'll be looking at bringing a claim for the loss of earnings of your military career, but also any subsequent civilian career that you may have had as well. And it's not just earnings that we're looking at. We look at loss of benefits and also the loss of pension as well.
And you mentioned there about current loss of earnings. That's something I wasn't really aware of. So I guess that could have affected if you stayed in service, but you was unable to get promoted, or you was unable to go on different tours, operations, and then the different kind of payments that you get through the military. You'd have a loss there, I guess.
Yeah, in our experience, there's a couple of different positions that you could be in for us to consider an employment expert. The first and the most obvious one would be a military discharge down to that injury. And the second one is just what you touched on. If you've been downgraded in service, but you've been prevented from doing certain things in service, you could have missed out on longer separation allowance or overseas allowance because you weren't able to go on an exercise or promotional course that you would have been on had you not been downgraded for that injury. And that all comes at a loss to that claimant if they can prove that they would have been on it but for that injury. Another example would be that you would have been on a promotional course and you could have promoted and gone through the ranks in service, but you were prevented from doing so because of your injury. Even if you were prevented just by a year or two because you couldn't go on a cold weather promotional course, it could mean that you would have stayed on the same income, but those that didn't sustain the injury could have gone on to promote and earn more. And these are all different examples of loss of earnings that we consider.
I think the key is that we're looking to put the claimant back in the position they would have been in but for the injury. Yeah. So that's how we would assess any compensation, to try and put them back in that position. had they not had the
And I
non-freezing
think
cold
that's what's
injury.
fair and right, isn't it? Yeah, okay.
Other special damages that we also consider is out-of-pocket expenses, expenses that the claimants had to incur just because of that injury, so expenses that they wouldn't have spent their money on had they not been injured. So in these types of claims, they can include specialist kit, such as specialist socks, boots, gloves, that they might have just bought standard shopped anywhere and bought those equipment or clothing, but because of the injury they're having to spend additional money to make sure that they've got the best protection to manage their symptoms, and we consider that when valuing a claim. Other examples for these types of injuries is that claimants often tell us that since having the injury they spend a lot more on heating and electricity, because they don't want to trigger their symptoms and the injury. And obviously, given the current climate, everyone's utility bills are going up, and they unfortunately are feeling that more than anyone else.
Yeah, makes sense. Okay. And I guess the big question on people's lips when it comes to making a claim, how do you fund a claim? What's the process there?
So here at Hugh James, most of our claims are taken on a conditional fee agreement, and this is widely known as a no-win, no-fee agreement. That agreement is entered into by Hugh James, but also by the claimant, and it sets out the responsibilities of both parties. Before entering into that agreement, the inquirer would have to give us some basic information about the claim, and we would have to measure whether we think there are reasonable prospects of success. If we agree to take on that claim, we would offer the inquirer the opportunity to enter into that no-win, no-fee agreement. And like I said, majority of our claims are with those agreements, and they are exactly like they set out. If you don't win your claim, you don't pay, and if your claim is successful, we take something known as a success fee off those damages.
Yeah, so the important part, I guess, is there's nothing to pay up front. It's all sorted out at the back end of a claim. If you're successful, if you're not, there's nothing to pay, full stop anyway. So
if you went into that agreement, there is no upfront fee. There will be no fee if your claim is not successful, so long as you adhere to the terms of the conditional fee agreement.
Yeah, important.
It is, that is important.
Yeah. Okay, and we've spoke about in other videos the Armed Forces Compensation Scheme or the War Pension Scheme. So could you bring two claims in side by side, essentially? So a claim under either of those schemes and a separate claim, a civil claim for a non-freezing cold injury.
Absolutely, you can bring both at the same time. I would advise anyone that thinks that they may be eligible to make the necessary inquiries for either of those schemes and put in an application as soon as possible, so as they don't fall outside any time limits that may apply. There's often a misconception that if you put in an AFCS claim that you're not entitled to then pursue a civil claim. That's absolutely wrong. You can do both, and we have experience of dealing with both at the same time in our cases. So the answer is yes, you can bring both claims.
Okay, great information again. So you mentioned earlier, Nia, about claims being time sensitive often. So if somebody's out there now watching the video and thinks that they may have had a non-freezing cold injury, what's the next steps for them? What's the actions?
If they recognise that they might have a cold injury, or if they've been diagnosed with having a cold injury, whilst in service, I would urge any individual to seek specialist military legal advice. Like you've mentioned, there are situations where claims are time sensitive, and if you are aware that you've got the injury and you decide not to bring the claim, you are at risk of being prevented from bringing the claim in future. So I would urge anyone to contact a specialist military solicitor. Even if they've been unsuccessful with the Armed Forces Compensation Scheme or with the War Pension Scheme, that doesn't mean that they won't have prospects of bringing a civil claim.
Yeah, so act now is the moral of the story, I guess.
Absolutely, and just to touch on the AFCS scheme as well, if you if you get compensation through that scheme and then you also have a successful civil claim, whatever you're awarded under the AFCS scheme is then it's deducted from the civil claim that you get, so you don't get double compensation.
Yeah. Okay.
So that's just something to bear in mind. But either way, you're going to be better off pursuing a civil claim, because our experience is that the AFCS claim, the compensation awarded isn't sufficient for the injury sustained.
Right.
Yeah.
Okay. So, okay. Lots of great advice there, both. Thank you very much for bringing it to our attention and educating me on a monthly basis when we do these videos. As always, it's a pleasure, and thank you very much for taking the time out of your busy days.
Thank you very much. Thank you.